Good morning, everyone, and welcome to the latest in Shepherd and Wedderburn's Property Dispute Resolution Group's round of seminars. My name is Colin Archibald. I'm a partner in the Property Dispute Resolution Group. And with me today are my colleagues Stephanie Hepburn and Dan Bain. And what we're going to talk about this morning is commercial real estate portfolios, current trends, and recent cases. We've talked about some similar themes over the last year, 18 months, but with the ongoing sort of upheaval in the economy, if I can call it that, we're continuing to see new issues cropping up, old friends reoccurring. And what Dan and Stephanie and I wanted to touch on today are some of the things that are particular features of the current marketplace in our experience, picking up on some of the themes from some of our presentations over the last 18 months and some new features of the last 6-9 months in particular. Because we're doing this virtually, there is a little bit less to do by way of housekeeping. A couple of things to flag are that we will provide a copy of the recording after the seminar. And as ever, we're also interested in any feedback that you want to provide in relation to the topics covered today and topics you'll be interested in hearing from us about in the future. The one other point to flag is that we will obviously be happy to take questions. Our plan is to pick them up at the end, and you should be able to submit them via the chat box. And Stephanie, Dan, and I will be happy to deal with anything that anybody wants to ask in the course of the session. And the beauty of doing it online is the questions can be asked anonymously, so don't be shy. I think that's probably all I want to say by way of introduction. I'm now going to hand over to Stephanie, who's going to get us going, talking about some particular themes in relation to summary diligence. Steph.
Thanks, Colin. Good morning. As Colin mentioned, we've also emerged from the pandemic, and as a result, the restrictions on a landlord's ability to recover arrears from tenants have now been lifted, which means that commercial landlords have really got now back to having the full plethora of options available to it for dealing with arrears. And we're seeing increasing levels of arrears as we emerge from the pandemic. So I'm going to look at what options are available to a landlord looking to recover rent arrears without raising a court action, and then Dan will cover a court action and recovery of arrears other than rent. So a process called summary diligence, and that can be carried out for certain debts without court action being required. It's really just an expedited means of enforcing debts, and I'll look at two of these diligences this morning, arrestment and attachment. The landlord must have a document of debt, which in a landlord-tenant situation is usually the lease, as long as that is registered in the Books of Council in session, which most commercial leases in Scotland, certainly FRI ones, are. The debt due to the landlord must be identifiable or set out in the lease, and that's quite straightforward in the case of rent, but issues can arise in relation to service charge, insurance, and also interest, which are arguably not identifiable from the lease, and Dan's going to cover that later. One issue that sometimes arises is if you have rent that's varied, say maybe in a back letter or a minute of variation that's not registered, there's an argument there that summary diligence can't be carried out because the debt isn't ascertainable from the lease, which is registered. It's either in the back letter or the variation, which maybe are not registered. So that's something to bear in mind when you're looking at your lease documentation. It's possible for the diligences to be undertaken simultaneously. I would always recommend seeking legal advice, not only in relation to the lawfulness of the options available to you, but the tactical nuances that can arise when you want to undertake diligence simultaneously. So it's worth seeking advice if you're wanting to do that. Before looking at arrestment and attachment in more detail, I wanted to touch quickly on the charge for payment. That's a prerequisite to attachment being carried out, and that means you can't proceed with attachment until the charge for payment has been served and 14 days have expired without payment. And it's served on the tenant by sheriff officers. It's often an effective enforcement method of itself, usually because the tenant's given 14 days to pay, and if they don't pay it, it can be wound up. So the charge for payment has got some bite. It's also quick and it's fairly inexpensive to do. It doesn't have to be served before an arrestment can be carried out. I'll now look further at arrestment. An arrestment is used where money or movables are held by a third party that belong to the tenant. And the most common form of arrestment that's used in a landlord-tenant situation is bank arrestment. The arrestment is served on the tenant's bank, which prevents the bank from then releasing the funds held in the tenant's account. The amount that's arrested is limited to the amount of the debt, including charges, interest, expenses, etc., or the amount that's held in the account by the bank, whichever is less. It's a cheap process, but it's not quick. So the bank must disclose the value of the funds arrested within 3 weeks of the arrestment being served. But the funds aren't released until 14 weeks after the service of the arrestment, unless the tenant gives some sort of mandate or written letter that the sums can be released sooner than 14 weeks. The tenant can object, so it can say the debt's not due. There would then be a court hearing that would follow, and the arrestment can then be recalled or restricted. The key thing with arrestments is that timing is crucial. They're only effective over money in the bank account when the arrestment is served. So if you serve an arrestment on the Monday and there's no money in the bank account, the tenant puts in £1 million on the Tuesday, the arrestment won't catch that £1 million. It won't catch anything because at the point of service, there wasn't anything in the bank account. The biggest challenge with arrestments is identifying where to serve them. Sometimes agents will have details what bank accounts the tenant banks with, and we can serve them there. But the prudent course of action is to serve on all of the major banks in Scotland in the hope that a tenant holds an account with one of them. So to that extent, arrestment is speculative. Looking at attachment then, attachment is a diligence that's quite disruptive. So landlords quite like it, tenants don't. It can be very effective in certain circumstances. You've got to serve a charge for payment first, as I mentioned, and 14 days must pass before the attachment can be carried out. You can do money attachments, and that's where a sheriff officer turns up at the premises and takes money or cheques or other instruments of debt that are in the till or whatever. It's quite rare, and I think it's unlikely nowadays to recover much money. We've got a cashless society where card and that's used much more often. So I don't think money attachment is very common nowadays, nor would I expect it to recover much amounts belonging to the tenants in the premises can be seized and sold at auction. Sheriff officers physically attend the premises and attach the goods. It's not a physical attachment. They don't do anything physically when they go. They just prepare an inventory and evaluation of all the goods, but the goods then can't be sold to a third party, which creates an immediate problem for the tenants. If it's a shop, for example, and all of the stock is attached, it can't then be sold to customers. It's quite disruptive because normally you would do it when customers are in the premises during trading hours. And it's not just the lease premises that you can go into, so it's any premises that the tenant has in Scotland. The sheriff officer who is doing the attachment has the power to open, shut and lock fast places to attach goods, and they must arrange for a professional valuation if that's appropriate. Once the attachment is carried out, you've got a period of 14 days whereby the tenant can challenge the attachment. If there's not a challenge or a challenge isn't successful, the report is then sent to the court and the attached goods are at that point physically removed and taken to an auction. Usually the threat of assets being sold prompts the tenant to either pay or enter into a dialogue or make a settlement offer. But if the auction has to take place, then the sums that are obtained at auction are used to pay share officers' fees and outlays first, and the balance is then applied to the sums due to the landlord, with any surplus being passed back to the tenants. If the items don't sell at auction, though, the ownership of the goods passes to the landlord. So you've got to bear that in mind. If these goods haven't got much value at auction or aren't very saleable at auction, there's not a market for them, the landlord's going to be left with ownership of them. So doesn't want that, maybe not in certain circumstances. One difficulty we see with attachments is that often goods are held to the order of a third party, sometimes on a retention of title, and that's quite common with pubs and restaurants. So if that's the case, they can't be attached, or if they are attached, the attachment can then be challenged. There are items that can't be attached, so tools of the trade or books used for the tenant's profession, and also vehicles that are reasonably required by the tenant also can't be attached. And there are days and times when attachments can't be carried out unless authorised by the court. So Sundays, public holidays, and between 8 p.m. and 8 a.m. So if you start an arrestment at say 4 in the afternoon, it can't go on beyond 8 p.m. So you'd have to stop unless you get the consent of the court to continue. It's quite common for pubs, restaurants, other hospitality venues to get consent from the court in advance to try and do the attachment out with 8 a.m. to 8 p.m. Because sometimes the operating times of these businesses mean that a visit at say 11 p.m. at night is going to be more effective than one at 11 a.m. in the morning. I was having a think when I was preparing for this webinar about items that I've attached, to give you some examples. So recently, just after lockdown actually, we attached clothing and stock from a now insolvent clothing store. We've also attached stock and fixtures and fittings from pubs and restaurants, and I've also attached sheep. So I once attached 800 sheep in satisfaction of a debt owed to an estate owner by a tenant, and we then sold these sheep at auction. The challenges that we came across in that case are quite a good example of why you have to think quite carefully about attachment before you go ahead. So in that case, the landlord became responsible for the animals' welfare when the attachment took place, and we had to put steps in place to make sure all of the welfare obligations were complied with. There were things like dead sheep that had to be removed and couldn't be sold at auction, so the landlord had a responsibility to deal with that. And we had to instruct shepherds and liaise with the shepherds as to how to herd all the sheep and how to identify which sheep actually belong to the tenant. A colleague also reminded me yesterday that we once looked at attaching pizza ovens from a well-known restaurant chain that was about to go into administration, but we soon realised that the second-hand value of a pizza oven was not worth the cost of the attachment itself. So once we had taken off the fees and the outlays, there wouldn't be much left for the debt. So you've got to also bear in mind, what is the value you might achieve at auction, bearing in mind you won't get full value, and how does that sit with the value of the debt. So I think it's fair to say that attachment is probably only really effective for higher value debts. In my example of attaching clothes from a retailer and the use of diligences simultaneously, this was just after lockdown, and the arrears were about £80,000, I think. The retailer had hundreds of stores all over the UK that had all just reopened following the lifting of the COVID restrictions. And we served an arrestment, but rather than wait the 3 weeks and then 14 weeks for the money, we simultaneously served a charge for payment and then began to prepare for an arrestment. And in that case, we picked the retailer's 5 biggest Scottish stores, and we started there, and with everyone lined up at each store to go around all of the stores until they were satisfied that enough stock had been attached to the value of the debt. You can normally expect to recover between 30 and 50% of the value of the stock at auction, so that also has to be borne in mind when you're calculating the value and how many stores you have to hit to get the value of the debt. So you might have to attach quite a lot of jumpers to realise the full value of the debt. And in that case, When we hit the first door, it opened up a dialogue with the tenant, and they were obviously keen to resolve matters, to remedy the attachment and stop the attachment. It was quite visually disruptive. Like, people in the stores, customers were asking what was going on. But as we were negotiating with the tenants, the attachment was continuing, so it put a time pressure on the tenants to negotiate with us and to try and come to a settlement, because they wanted to avoid the attachment. And in the end, in that case, we reached a deal and were able to release the stock from the attachment, so it didn't have to go to an auction. But it's a good example of how we use two diligences simultaneously, but also the questions you have to ask yourself when you're thinking about attachment. So I'll now hand over to Dan. Let me stop sharing my slides, and Dan is going to look at court action and recovering arrears other than rent. Hopefully that's worked, Dan.
Thanks, Steph. So working out how to unmute myself. So yeah, sticking on the topic of monetary breaches of a lease for now. Steph's obviously just covered their summary diligence, which are the sort of essentially summary enforcement methods you can carry out without needing a court order and using a registered lease. I come on to talk about court action where you can't carry out summary diligence. What you can do in a court action, and I'll cover diligence on the dependents, diligence in execution, and also touch briefly on irritancy. Just before coming on to talk about that, Steph mentioned earlier on that to use summary diligence, the debt in question has to be ascertainable from the document, the registered document. And often what that means in practice when it comes to monetary breaches of a lease is that recovery of rent by summary diligence is fine, because that can be ascertained on the basis of the registered documents. But with service charge, that's a bit more difficult, because very often it's not apparent, the amount of service charge due is not ascertainable from the lease itself. For that reason, ordinarily, we wouldn't recommend using summary diligence for recovery of service charge. And the risk, if you did, is if it transpires, if you use summary diligence on the basis of a registered document, and it transpires that there wasn't a basis for doing so, it may be challenged by the tenant. And if it's found that in fact there wasn't a basis for doing it, then that could give rise to a liability and damages for the landlord for wrongful diligence. The sort of risk of that is always going to depend on the circumstances, whether that's a high risk, a low risk, or whatever. But that is the risk, I think, that presents itself if you use summary diligence to recover service charge, if it's not clear that there's a basis for doing so. Now, it may be that in certain circumstances there is a basis for doing that, depending on what the service charge mechanism is. There was a case, a Supreme Court judgment and an English case issued earlier in the year. It's Sarah and Hossain against Blacks, in which a landlord sought summary judgment. So this wasn't a case about summary diligence, because it was an English case, but a landlord sought summary judgment for recovery of service charge arrears on the basis of a certificate that was issued by their surveyor in terms of the lease. The tenant made a counterclaim in response to that, and it made its way to the Supreme Court, and the Supreme Court determined that on the basis of the terms of that lease, the basis of the mechanism in that lease, the landlord could get summary judgment for the service charge arrears, but the tenant could continue with their counterclaim, so they could continue to challenge it on the grounds that were available for challenge in terms of the lease. Now, does that mean that you could, on the basis of that case, could you then, if you've got a provision in a lease in Scotland whereby the landlord's surveyor can issue a certificate certifying the amount of the service charge, can you then recover that by summary diligence? I'm not convinced, because I see that the circumstances were different there. What the court determined was that the landlord could get summary judgment, but the tenant could continue with their counterclaim. I think much will depend on the precise mechanism, and if the certificate is issued and if summary diligence was carried out, is there a means whereby the tenant could can continue to challenge that liability? I think that would be the key question, because in that Supreme Court case, there was a means by which they could do that, because they'd made a counterclaim in response to the landlord's claim for summary judgment. So I would be wary about it, but depending on the terms of the lease and the precise mechanism, it's something that may be possible. But if you can't use summary diligence, well, in the case of a monetary breach, or in fact in the case of a non-monetary breach of a lease, you're then looking at, for a landlord, raising court proceedings. Now, I'll just pause to say that before embarking on any court proceedings, it's always going to be necessary to check whether there's an alternative dispute resolution provision in the lease. Some leases will have provision in them for, in terms of which the parties have agreed that any dispute must be referred to arbitration. So it's important to bear that in mind. ADR is out with the scope of this seminar, so I won't get into that, but it's just something to flag and something to bear in mind before a landlord embarks on court action. Now, in terms of court action, you're looking at either the Sheriff Court or the Court of Session. Which you use will depend on the circumstances, including the value of the claim, but also, there will be geographic considerations as well. Whether or not you want to instruct counsel, because if you go to the Court of Session, you need to instruct counsel or a solicitor advocate. So there are various considerations that apply, but there are also financial limits. In the Sheriff Court, claims with a value of £100,000 or less have to be raised in the Sheriff Court. You can't raise those in the Court of Session ordinarily. And if the claim has a value of £5,000 or less, then it has to be raised in the Sheriff Court, but using the simple procedure. In the Court of Session, that's for claims with a value over £100,000. Worth mentioning that in certain Sheriff Courts and in the Court of Session, you can raise your action as a commercial action, so there are differences in procedure there. And the benefit of doing that is that there's a hearing before the sheriff at an earlier stage. There's much more sort of case management by the court at a much earlier stage, and that can help in moving the case along, but also it might help in reaching a resolution at a much earlier stage. So that's worth bearing in mind as well. Now, Colin mentioned earlier upheaval in the economy. We are living in sort of turbulent economic times. If you're about to embark on a court action as a landlord, what if you're thinking that there's a risk that actually ultimately if you get a decree for payment, it might not be worth much? What if the tenant actually is not going to be in a position to ultimately pay the sum due? I mean, that's absolutely something that needs to be considered at the point in time when you're about to embark on raising a court action and incurring the cost of doing so. But there are certain steps that can be taken to provide security for the sum claimed if you think there is a risk that ultimately an order for payment is going to be, or there's a risk that you might not be able to enforce an order for payment at the end of the day. And that's where a form of diligence called diligence on the dependents comes into play. Now that can be sought in either Sheriff Court or Court of Session actions, and crucially, it can be sought before service of proceedings. So if you think there's a risk that, if you're alerting the other side to your application, which ordinarily you would need to do, if you alert them to, if you think there's a risk that in alerting them to it, they might dispose of or conceal assets, well, you can make the application and seek a warrant for diligence on the dependents before before anything is served on the defender. So you've got that sort of element of surprise, if you like. There are three forms of diligence on the dependents: arrestment on the dependents, inhibition on the dependents, and interim attachment. Steph explained earlier what arrestment is and what attachment is. It's the same, broadly the same procedure, and it broadly has the same effect when it's diligence on the dependents. Inhibition, just very briefly, is a form of diligence that essentially prevents the defender or the debtor from disposing of heritable property they own. Now, we can always check, I guess, using the property registers whether they own any property, but very often a tenant is a tenant of properties and doesn't actually own any heritable property. But it's always worth checking because that is sometimes, depending on the circumstances, a useful form of security for a debt due, because it essentially freezes the heritable property. You can't dispose of the heritable property that you own until whilst the inhibition remains in place. So that's the three forms of diligence of the dependents. Now, when you make an application for a warrant for diligence on the dependents, there has to be a hearing. The court has to give the debtor an opportunity to be heard. But I mentioned earlier, the warrant can be sought before anything has been served on the defender. It can be sought before a hearing, and that's important, as I say, if you think there's a risk of the debtor disposing or concealing of assets. If you do make an application for diligence on the dependents before a hearing, and by that I mean a hearing at which both parties are present, there are certain conditions that the court must be satisfied of. And ordinarily there will be a hearing, but not a hearing at which both parties are present. The court might want to hear from representatives of the applicant in order to be satisfied that these conditions are satisfied. But that's a hearing at which the debtor or defender is not present. So the conditions are that the creditor has what's called a prima facie case. Broadly speaking, what that means is that the creditor has, on the face of the documentation, a good arguable case. And also, it's a condition of getting a warrant that the court is satisfied that there's a real and substantial risk that if an order for payment was granted, if the order was granted after a hearing, the enforcement of the decree, a decree for payment, would be defeated or prejudiced by either the debtor being insolvent or verging on insolvency, or the likelihood of the debtor removing, disposing, burdening, concealing, doing something else with their assets. Also, the court has to be satisfied that it's reasonable in all the circumstances to grant the warrant. Now, it's quite a stiff test, broadly speaking. It's quite a hurdle to get over. To satisfy the court that all of these conditions are met. It's not easy. It is quite a high hurdle, and you need to have material to present to the court that demonstrates these things. So that's worth bearing in mind. If you're wanting to make an application, there will need to be some evidence that you can present to the court to persuade the court that these conditions are satisfied. But it's definitely something that's worth bearing in mind if, as I say, you think that there's a risk that ultimately an order for payment at the conclusion of the court action might be unenforceable because of the tenant's financial position. If warrant for diligence is granted before a hearing at which both parties are present, the court must then schedule a hearing for both parties so that the debtor has an opportunity to be heard. And it's the same at that hearing. It's the same conditions that need to be satisfied. The court will look again at the same conditions, and the onus remains on the creditor to satisfy the court that those conditions are satisfied and that the diligence on the dependents should remain in place. I mentioned your diligence and execution as well. That's where you have ultimately the conclusion of your court action. You get a decree for payment. Diligence and execution, that's enforcement of the decree, once you have that. And the methods are broadly the same, and they include arrestment, inhibition, which I've mentioned, attachment, money attachment, which Steph spoke about. So, the methods of enforcement are broadly the same, but the difference is that you now have a decree for payment. It's not summary diligence, it's not on the dependence of the court action, it's with the benefit of a court order. I'm going to mention briefly irritancy as a means of enforcement. I won't talk about this in detail. We covered this in a seminar last year, which I believe is still available. I can check that, but it's worth mentioning because it can be quite an effective means of enforcement for both monetary breaches or non-monetary breaches. And as many of you will know, irritancy, that's termination of a lease by a landlord on the ground of a breach by the tenant. There needs to be an irritancy clause in the lease, but almost every commercial lease does have that. And that will provide the bases for termination, which are usually a monetary breach, a non-monetary breach, or insolvency of the tenant. Irritancy is subject to statutory protections to ensure that it is exercised fairly. Those are contained in the Law Reform Miscellaneous Provisions Scotland Act 1985. In relation to a monetary breach, broadly speaking, the protections are that a pre-irritancy notice has to be served first, requiring the tenant to pay the outstanding sum within a specified period of time. And that has to state that if the tenant doesn't comply with that, the lease may be terminated. And the specified period of time has to be at least 14 days longer if the lease provides for that. In relation to non-monetary breaches, the lease can't be terminated if, in all the circumstances of the case, a fair and reasonable landlord wouldn't do it. What the legislation also provides is where the breach is capable of being remedied within a reasonable period of time, then in determining whether it's fair and reasonable to terminate, the landlord has to consider whether the tenant has been given a reasonable opportunity to remedy the breach. There is some case law on the application of that fair and reasonable landlord test in certain different scenarios. There isn't time in this seminar to go into that. It was covered a little bit in the seminar that we had last year. So assuming that is still available, you could look at that. I'm happy to answer any questions about that if anybody does have any questions about that. And I will now hand back to Stephanie.
Thank you. Let me just share my screen again. Let me know if you can see these slides then, just make sure they're running okay. Is that okay now?
Yep, I can see the slides.
Great, thanks. So, of course, it may not just be payment of money that the landlord is seeking. Dan's obviously touched on termination of the lease, but if the landlord is not wanting to terminate the lease, they might find themselves wanting to enforce performance of an obligation in the lease. So Colin and Dan have both touched upon the economic climate and economic uncertainty that we're facing at the moment. And as you all know, in these situations, a property may be difficult to re-let, or the tenant might find it challenging to find a new party to assign the lease to or to sublet to. But a tenant which is trading badly but can't get out of the lease may decide to cut its losses by vacating the premises but continuing to pay the rent. And landlords of shopping centres don't like this, or retail parks don't like this. At the very least, it creates a blank frontage. But if the tenant in question is an anchor tenant, then the viability of the centre may even be at stake. Interim interdict can be sought against vacating the premises, and we've done this where the landlord gets a wind that the tenant's going to do a midnight flit or whatever. But landlords can also enforce keep open provisions in leases by a court order, which essentially is telling tenants to go back, keep open and trade from the premises. And that's what happened to Marks and Spencer's shortly after the first lockdown in 2020. A dispute relating to a Marks and Spencer retail unit in East Kilbride shopping centre. There was a lease between Marks and Spencer's and its landlord. It was a 99-year lease from 1972, so it still had until 2071, quite a long way to go until the end of the lease. And the lease placed an obligation on M&S to keep open and trade from the store. I've put the clause on the slide there. I won't read it out, but you can see that they had to be a retail store. They had to keep the unit open for business during normal business hours, and maintain lighting in the shop display windows, and also be a substantial retail store. So when the COVID restrictions were introduced in March 2020, the store remained open for the sale of essential foodstuffs from the food hall within the M&S premise. And access to this food hall was via an outside entrance, but there was also another entrance from within the mall that in the lockdown pandemic, the mall entrance was shut. They also put up a high sort of full length white unit that separated the food hall from the remainder of the clothing part of the ground floor. And you'll see from the slide, the image on the left there, this sort of black film was attached to the glass frontage and the doors within the mall. And there were signs put up, you can't see the image there, but there were signs put up that told customers to go around outside the mall to the outside entrance with the food hall image on the right hand side there. So when the COVID restrictions were lifted, the landlord expected M&S just to go back to normal and resume trading as it had done before the lockdown, but it didn't. The sale of food was depleted to the extent that by sort of mid-July 2020, there was only one shelving unit selling biscuits and juice. There was no stock within the clothing area, and this white dividing wall remained in place. There was no Percy pigs or colony caterpillars anywhere in sight. And a sign on the door told customers to go to a different M&S store in East Kilbride. So in July 2020, so a few months after the pandemic had began, the landlord raised an action in the Court of Session and got an order requiring M&S to reopen the store in full. And a copy of the order is on the slide there. I've highlighted the key parts to look at. So it called before Lord Braid, and you'll see that the obligation on M&S was to reopen the whole of the premise, keep them open for business as a retail store, and the last bit's quite important, keep the premises sufficiently staffed, stocked, furnished, otherwise equipped for that purpose. And you'll see that M&S were given until 24th of August 2020 to comply. Lord Braid recognised that it might take some time to restock and restaff the store. Then what happened? Well, M&S turned this big retail store into an outlet store. The food hall was no more, didn't sell kids' clothes or any health and beauty products, which were key product lines for M&S and other stores. The entrance within the mall remained closed, and the windows in that image that I showed you remained blacked out, and all signs on the closed doors were removed, giving the impression really that the store was shut. Lord Braid commented that the low stock levels were more like a store destined for closure rather than one open for business as usual. So the landlord hired a private investigator who carried out sort of some covert visits and spoke to staff and what customers there were in the store. And the general consensus among staff and customers was that it wasn't a case of if the store was going to close, it was when the store was going to close. In some video footage, there can be no customers seen at all, despite the video taken at lunchtime on a Saturday. And Lord Braid, funnily enough, said that he fleetingly thought he saw several customers on the video footage, but on closer inspection realised they were mannequins. Staff levels had dropped from about 15 staff in the store to 3, and security guards were wearing high-vis jackets, and those security guards outnumbered M&S staff. So it was all pretty dire. As you can imagine, the landlord was not happy. It had a lease which placed a clear obligation, as we saw back on the clause 10th in the lease, to keep open in trades, and also went to the expense of getting an order from the court to require M&S to do so. It was accepted in the case that M&S were entitled to shut the food hall and also operate as an outlet. There wasn't anything in the lease that obliged M&S to have a food hall or didn't preclude an outlet from operating either. But because the landlord had gone to all this expense of getting a court order, it didn't consider M&S to have complied with that order. So it took a very, very robust approach actually, went back to court alleging a breach of the court order, and also argued that M&S were in contempt of court by failing to reopen the premises in terms set out in the court order. Because the landlord couldn't challenge the fact the food hall had shut or the trading as an outlet, the argument really focused around 3 things: the failure to reopen the mall inside entrances, the reduction in staff numbers, and the levels of stock within the store. M&S, as you can imagine, argued that all it had to do was keep the store open and trade from it, and it was doing that. There was no obligation in the lease that we see in some other commercial leases to trade as a high class or high end retail unit or high class shop or anything like that. And it said, I see the argument why they're making this argument. It said that the manner of its operations was entirely up to itself, and it wasn't up to the court to micromanage the lease or how M&S operated the store. There wasn't a provision in the lease or the court order which expressly required the mall doors to remain open or to be opened, nor did the order or the lease specify any staff levels or stock levels. If we go back to the court order, the last sentence there, it does say keep the premises sufficiently staffed, stocked, furnished, otherwise equipped for that purpose. But the question was, well, what does sufficiently mean? There were really two questions for the court. Firstly, had M&S complied with the court order? If it had, it couldn't be in contempt of court. But if M&S had breached the court order, the question around contempt was that breach sufficient enough to amount to a contempt of court? So was the breach serious enough to be a contempt of court? And Lord Braid said that whilst he accepted there was some ambiguity about the sufficiency tests that was mentioned in the court order, that led to a sort of ambiguity about what stock or staff levels were sufficient. He also said, though, that it was clear that M&S had been ordered to open the whole of the retail units to trade in good faith and not carry on business, in his words, half-heartedly. He found that this half-hearted manner of trading put M&S in breach of the order, and he said they were simply doing the bare minimum, and that wasn't good enough. He pointed out that M&S had been occupying the store for 40 years, that we see in other stores, and had always had access from the mall store as well as the streets. So if they had resumed trading in that manner, they wouldn't have been in breach of the court order, they would have been in compliance with the lease, and plainly Lord Braid said M&S knew what it had to do. So he reviewed M&S's actions following the court order, and what sort of things did he look at? We've got two slides here. There was quite a lot that he took into account. The first thing was his failure to reopen the mall, the inside entrance, and he said that by failing to open that entrance, M&S had failed to open the whole units. It didn't matter that the mall entrance hadn't been specified in the court order. The limited use which M&S were making of the available space was evidence, he said, of a failure to reopen the entire units. Blacking out the windows gave the impression the store was closed. Failure to exhibit a sign telling customers to go to the outside entrance gave the impression from the inside, at least, the store was closed. Signage to a food hall that no longer exists. So remember in that photo I showed you, the M&S food hall sign was there. That wasn't removed, and Lord Braid said that because that never existed, the signage was still there, that was a sign of half-hearted trading on M&S's part. There was also an intention, which was admitted by M&S, they wanted to close this store. It was all kind of press reports at the time that their intention was always to close this store, and that was reflected in the witness evidence at the court hearing, and Lord Braid took that into account as a sign of half-hearted trading with the intention of closing eventually. He looked at the low stock levels. He looked at the M&S's operational choice to operate as an outlet store when no other store that M&S had in a comparable size and a comparable location was an outlet store. It was surprising this store was changed to an outlet store, and that demonstrated an intention really to close the store or trade beyond the full operational units. He also looked at comments by staff that the store was destined really for closure, the failure of staff to wear M&S uniforms, the dearth of customers at peak shopping times on a Saturday, the belief amongst shoppers, other retailers, that the store was not open. He was really quite scathing, actually, of M&S's actions, and you've got a quote here. He said that M&S had pushed the envelope by doing what it considered to be the bare minimum to comply with the order. It is not enough. Marks and Spencers must do more. He didn't go so far as to find M&S in contempt, which would have had sort of quasi-criminal consequences. He would have had to have been satisfied to find M&S in contempt that there had been willful conduct, which showed a disregard really for the court. And he did say it was marginal. I think he was quite close to finding M&S in contempt, but he was prepared to give him the benefit of the doubt, recognising that there was some degree of uncertainty about the sufficiency of stock levels mentioned in the court order and the hours and the space which was to be traded from. And also that M&S were making these choices based on the benefit of legal advice. It's worth a read. It's quite an interesting case. It's fairly short as case reports go. I think it's a useful reminder that if tenants are thinking about making these operational decisions, especially in the current market, if they want to close or change the manner of trading, then you have to look at the lease quite carefully. What's the obligation in the lease? Is there a provision that restricts what your tenant wants to do? So always have a look at the lease. The case, I think, is also a useful reminder of the court's willingness to enforce these obligations and keep open provisions. It's been well settled in Scotland for a long time. The courts will enforce keep open clauses and leases, even in a difficult post-pandemic market. The courts are looking for full performance. Operating a limited store, a limited area of the store, as M&S did here, isn't enough. It's also, I think, a good reminder of the importance of drafting and clear drafting in new leases. We're stuck with old ones, but we can look at this for new leases going forward. In this case, the landlord was stuck with an old lease and a provision in that lease which didn't preclude M&S from trading as an outlet store, and it didn't preclude M&S from closing the food hall. There was no obligation on M&S in the lease to trade and have a food hall as part of that operation. I suppose it's likely that a request by a landlord to have this sort of level of specification or precision in a keep open provision might meet with some resistance. I suppose it might depend on the bargaining position of the parties, but this case shows what can happen if the landlord wants the store to operate in a certain manner, and that is not reflected in the lease. So the importance of clear drafting is key here. I think I'm passing back now to Colin, so I'll stop sharing these slides. Back to you, Colin.
Thanks, Steph, and I will now share my screen in a moment. If I can manage to do that. Just need to get my, apologies for the slight technical hitch. I'm just needing to, there we go. That was genuinely a case of the button being pressed but not working. So hopefully everybody can see that now. But yeah, I just wanted to talk similar to what Steph's just been discussing in relation to the recent Keep Open case. I wanted this morning to talk about a couple of recent decisions in relation to the remit of matters to a person of skill in the Court of Session. And so what I wanted to do, first of all, is just sort of talk a little bit about what the process is. It's perhaps not as familiar to people as it ought to be, not used as often as it might be, and then talk about the couple of recent cases and some lessons to be learned from them. So looking at the whole concept of appointment of a person of skill to deal with technical matters of fact, the person of skill will then report to the court on their findings. And as I mentioned, it's not something that is used a huge amount, something that might be used a little bit more often. There is express provision for it in the Sheriff Court rules, but not actually in the Court of Session rules for reasons I can't confess to having researched. But what the Sheriff Court rules annotations talk about is, first of all, it might be more useful if the sheriff had the power to order it, because it's only something that can happen if one or both or all parties agree to it, and also making the point that there is no reported case law in the Sheriff Court on the use of that process. We do have a few decisions. There have been a number over the last few years in the Court of Session, so maybe it is becoming recognised as a useful means of trying to, as I mentioned in the next bullet point, pass matters to somebody with a particular set of skills that can allow the scope of a subsequent hearing, a hearing of evidence, a proof, to be more limited. And what would happen in practice is that certain matters would be remitted to a person of skill in order for them to come to some to come to a conclusion on the issues that have been passed to them for their opinion. And it can be particularly useful in the context of dilapidations. If you think about a situation where, for example, you've got a schedule of dilapidations with 1,000, hundreds, or even 1,000 plus individual items, and the prospect of the matter going to proof and evidence on each and every one of those items needing to be dealt with before the court. And what can happen then is that the matters can be remitted to the person of skill. They can be set a task to address these matters. They report back to the court, and the prospect of days, or much more likely weeks, of evidence on each and every individual item means that hopefully court's time and therefore money can be saved. As an example, a number of years ago, Dan and I dealt with a matter where it was a large delapsed claim in respect of a substantial building, and there were two main strands to that one. There was the general sort of builder's work, fabric claims, but there was also a claim in respect of the M&E plant and equipment. And so what we did in that case was remit to two persons of skill, a building surveyor to deal with the building fabric claims, and an M&E engineer to deal with the plant and equipment matters. And their reports were then applied to assist the parties in negotiating a resolution. The matter didn't end up going to a full hearing, but certainly the prospect of running a proof to hear evidence on each of the, in that case it was thousands of items, would not have been a particularly attractive one for probably the parties and the judge perhaps above all. So it was a very effective way of dealing with matters more quickly and more cost effectively. The one thing, though, that can be a problem is the risk of a person of skill's role being the subject of dispute between the parties, and the process for agreeing the remit, as we'll go on to see, can be absolutely crucial to influencing the outcome of the process and how effective it can be. So I wanted to move on and talk about the first of the couple of recent cases, this matter of Hill against Apleona. In this, a dispute relating to a property at Hamilton International Business Park in Blantyre. And you'll be able to see that from the timeline on the following slide, that the lease came to an end in September 2020. There was then a dispute between the parties about the extent of the tenant's repairing obligations under the lease. Court proceedings were raised the following July. Parties agreed at a hearing in November of that year to remit, or the idea was floated of remitting matters to a person of skill. An order from the court to do that was granted in the February, but it took until almost the end of 2022 for the person of skill to provide their report, which in turn led to dispute between the parties that brought the matter back before the court in the following February. So the parties' positions try to summarise on the next slide the parties' positions in terms of the arguments that they were seeking to run. Now, what the landlord was saying, unsurprisingly, was that the repairing obligation under the lease required the tenant to pay the full costs of the work in the schedule. And what had happened in respect of a very substantial number of items in the schedule, a substantial number of the items remitted to the expert, the person of skill rather, was that they had simply said the matters were not proven because they didn't have sufficient information to arrive at a decision. And so what the landlord said was that the person of skill had failed to implement or exhaust their remits by not making determinations on the substantial number of items forming part of the claim and not seeking further information where the person of skill said further clarity was required. And in all those circumstances, the landlord wanted the matter remitted back to the reporter with fresh directions. Whereas on the other side of the fence, the tenant argued that the elapsed schedule included a significant number of items that fell out with the scope of the repairing obligation, that the person of skill fulfilled his remit and was entitled to find the elements of the claim were not proven, and that the landlord was not entitled to, as they put it, unlimited bites of the cherry by seeking a remit back to the person of skill in respect of matters where, to put it one way, the landlord has simply not received the decision it was looking for. So as far as the judge then went on to consider the law that ought to be applied, and perhaps one point just to emphasise is that the person of skill is, as I touched on at the beginning, looking at matters of fact or technical skill. They are not looking at the law. The law, unsurprisingly, remains a matter for the court. And so what the court said was that there were three uncontroversial propositions as far as they were concerned, which were, first of all, that the parties are bound by the terms of the joint remit, which prescribes the procedure to be followed and the questions to be addressed by the person of skill. And I think that is an absolutely vital point. We'll come on in a minute to touch on some of the difficulties that arose in this case, but a lot of difficulties in these circumstances can be avoided by the careful drafting of the remit. I mean, in simple terms, in the context of a delapse claim, you'll be wanting a person of skill to assess the extent to which there are wants of repair, the extent to which they fall within the scope as a matter of fact of the lease obligations, the extent to what requires to be done to fix them, and any associated costs of that work. There'll be detail around that, perhaps questions of process, but in general terms, there ought not to be too much rocket science, but it is very important to try and frame the reference in an effective fashion. And underlining what I've touched on already, where parties have remitted a question to a person of skill to determine a matter and that remit has been performed, the court won't allow another mode of proof. That's a slightly fancy court speak way of saying you stand or fall by the decision of the person of skill, the reporter, as long as they have done their job. The court, though, does have a jurisdiction to order further inquiry where the reporter has failed to exhaust or comply with the terms of his or her remit. And in this case, what was the outcome? Well, the court considered, and this is Lord Braid again, who's probably the best judge in the commercial court of the Court of Session, so his decisions always carry considerable weight, I think. He decided that the remit did not require the person of skill to embark upon a voyage of discovery. If there wasn't enough evidence, the reporter was entitled to conclude that. And whilst the use of the phrase not proven was perhaps a little bit too criminal lawish in nature. He was essentially saying that the landlord had failed on a balance of probabilities to discharge their burden of proof and prove that the claim was well founded. And so that was something that the person of skill was entitled to do. What they hadn't been entitled to do was, in certain instances, they said they couldn't find out whether works complained of where and hadn't been able to come to a view, and they'd failed to actually put numbers against certain claims. In relation to the first of those points, the sort of extreme example the court gave was, well, imagine if they hadn't been able to find the building at all, and they said, well, I couldn't find it, so I couldn't do my job. And that would clearly be nonsensical. They would have failed to do what they needed to do. But if you drill down and apply that broad principle to individual items, you can't just say, I'm not sure where this was, and therefore I haven't given you a view. They simply haven't addressed their mind to the matter. So they had to go back and look at that again, and where they failed to put numbers against matters, they needed to go back and do that. But it is important to emphasise that whilst the landlord enjoyed a measure of success, it was quite narrowly framed. And I think the overarching point was to emphasise the limits on challenging the determinations of a person of skill or a court reporter. And that point was underlined in the case I wanted to go on and touch on briefly, Ashton against Salim, which came a little bit later in the year, a different judge, Lord Harrower this time. I don't plan to say very much about this at all because it's not nearly so detailed in its examination of the whys and wherefores of the process, and much more focused on the detail of three really pretty technical challenges, objections to the report of the person of skill, which, as you'll see, were dismissed. And I think it's one of those cases where you read it and think the landlord was simply trying to find a way of wriggling out of a finding by the reporter that they didn't like. And the judge had no truck really with the very technical objections they made, making the point that at some point, by reference to the material provided, the reporter just has to make a decision. So what can we conclude from all of this? I think as far as the conclusions and lessons learned are concerned, it is, I think Dan and I would agree that it made a monumental proof into a much more manageable one when we used it with two persons of skill a number of years ago. So as a matter of principle, it's something that I think can be quite useful, and I've certainly contemplated it in much smaller sheriff court disputes in the not too distant past, where the prospect of days of evidence on minutiae of a delapsed claim before a grumpy sheriff is not an attractive one, and remitting it to a person of skill who deals with these matters on a day-to-day, week-to-week basis, and for whom it's their bread and butter, seems like a very good plan. But it brings us back to the question of remit. What questions are they being asked? What information will they be provided with? What powers will they be given? What, in terms of that power and the process, will be envisaged, stipulated so far as ongoing engagement between the parties and the person of skill is concerned, to try to avoid the impact of the sort of indeterminate conclusions that had an effect on the process in relation to the Hill against Afleona matter. And I think that is maybe one of the disappointments of that case, that it is something that I think can be a really useful process. The court was really pretty critical of the fact that it took a year to run its course and about 9 months from the point that the order was made, indeed 3 months to even get up and running, because the parties took 3 months to agree the remit after the order sending them off to go through the person of skill process was given in February. They only really kicked it off in May. So that sort of lack of planning and dilatoriness can have an impact on the potential benefits, but still important to keep it in mind as something in the armoury to use as a means of the effective management of small and large scale delapse claims. So that's all I wanted to say about that recent case this morning. We do have about 7 or 8 minutes left for questions if anybody has them. I'm just checking the chat box. I think one that Dan, I just wanted to pick up with you was just in relation to the mention that of the summary diligence case in the Supreme Court, not summary diligence, the summary judgment case in the Supreme Court, and potential significance for summary diligence up here. It still seems to me that it might be a bold client or a bold advisor that says it gives you a clear path to using summary diligence for some of the things that we have advised against using it for in the past. But I wondered if you had anything you wanted to add to what you talked about in your presentation.
Yeah, I mean, it's just, I think you're right. I mean, I think it would be a bold landlord. I mean, I think a lot will depend, as I mentioned, on the service charge mechanism, because where the court kind of ended up, the Supreme Court ended up in that case, was that they kind of determined that the sort of service charge regime, the mechanism in that lease, was what they described as a pay now, argue later regime. So I think it was quite important that, whilst yes, they ultimately determined that the landlord could get summary judgment, the tenant could continue with its counterclaim and challenge that. So I think that would be the key thing if you're trying to apply that to summary diligence. I think that would be one of the key things you'd need to consider if you know, if there is a certificate issued and if the landlord goes, well, I'm going to use summary diligence to enforce that and recover payment, so carries out an arrestment, for example, and freezes the tenant's bank account. Is there a means there by which the tenant can continue to challenge that liability? And that's where the two processes are not exactly the same. It's important to emphasise it was not a case about summary diligence. So I think it would be important in looking at whether or not you can use that case and apply that case to particular circumstances of your own case. I think a question of looking at the case in detail, looking at the case and at the particular service charge mechanism in your lease, and saying, well, actually, can we apply the principles from that case to the service charge mechanism we have here? And I think it would be important to take advice on it, because of the risk that if you do use summary diligence, if you do, for example, freeze the tenant's bank account to seek to recover the service charge, and it was ultimately determined that it was unlawful to do that, there wasn't a proper basis for doing that, then there is then a risk of a claim for damages against the landlord for wrongful diligence if the tenant has suffered some loss as a result of that. So yeah, I think you need to be careful about it, take advice before doing it. So yeah, not straightforward, not clear cut, I don't think.
And Steph, just picking up on something that was asked, and that I had a little sort of additional observation on, that as far as keep open is concerned, and just as an aside, we did have a keep open matter recently. We tend to have few of them for a long time because the law is so clear. Although we did have one that we needed to enforce recently, which I think was as much a problem of the tenant having a problem recruiting enough staff to keep open, as opposed to willfully not wanting to comply with their lease obligations. But one of the first things I did when I joined S&W in 2001 was a keep open matter. The law was clear then. I think it's still pretty clear today, and it's pretty landlord friendly, unless you happen to have a very old lease that doesn't give a satisfactory amount of explanation of what's needed to keep open and trade from a unit. And one thing that we can probably take from Marks and Spencer is it underlines the fact that tenants will struggle to come up with cogent reasons for not complying with a keep open provision, however unappealing it might be, or however uncommercial keeping the store open is for them.
Yeah, absolutely. I think the case law is so clear. There's been a few pretty big cases, not in recent times, but 20 years ago or so, 10 years ago, where it's so clear that the courts will enforce these provisions, and they do take them quite seriously. What I found quite interesting in the Martin Spencer's case was this argument around contempt. And if you do get an order, so a tenant gets an order to keep open and resume trading, you have to be careful to comply with that order, because if you are found to be in contempt, there's quasi-criminal consequences into that, and potentially quite high financial penalties as well. So it's really in the tenant's interest, if there is a keep open clause and it is enforced, to make sure that you're complying with the court order as well as the obligation in the lease. But no, the case doesn't change the law at all. It just restates I think it's the only case I'm aware of that's reported post-pandemic though. So I think it's interesting from that perspective that even in the post-pandemic market that we've got, the courts will still enforce these provisions and look at them quite carefully. Nothing's changed is a short answer.
I think that's right. And I suppose two things that immediately spring to mind from that are, first of all, that the courts have made clear that for 25 years plus that commercial considerations are not relevant. They'll be enforcing the parties' obligations, and they might feel a pang of sympathy, but that's a different thing from saying they're going to let a tenant off the hook in respect of its lease obligations. And in the context of COVID, there have been various arguments run by tenants, whether for reductions of rent or force majeure to try and get out of lease obligations. And here's maybe another species of that sort of argument. And the courts again are saying whether they feel a pang of sympathy or not, you can't do that, because that's not what your contract says. That's not what your lease says, and we're going to enforce your lease obligation. Well, I think
even if the tenant comes along with arguments. Sorry, no, I was just going to say, if the tenant comes on with arguments that they can't afford to go back or they haven't got staff or anything like that, the court will look at what the lease says, and if the lease, that's your obligation, then you have to go back. And unfortunate as it is, the court is not going to feel sorry for tenants and let them off the hook.
Exactly. I had one very last observation. I think we don't have any more questions, and we're pretty much on time now. So, which was, we have had a handful of matters in the course of this year that have come our way where a document has not been registered in the books of council and session. So asset managers, managing agents, if you have tenants that are causing you a problem, just double check and triple check that all your documents are registered for execution, because it's better to check that in advance than to find out that you're scrabbling around trying to get something registered when you want to act on it. And the other thing was, Dan mentioned the availability of previous seminars, which I think are all on the Unmissable S&W YouTube channel. So this will go there eventually too. You can find our previous sessions on that. Beyond that, I just wanted to say thank you to Dan and to Steph. Thanks to everybody who has dialed in today to join us. The recording will be available in due course, and I look forward to seeing you on some of our events in the future. Thanks very much.
Thanks.